Yes, any mentioning?
My lord, for application, my lord.
My lord, I was seeking leave to mention the matter for inclusion in the list, my lord. It's an appeal from an order passed in the Group 9 residuary bench.
Yes.
My lord, my junior is there. She will give the appeal number. It's a Group 9 may appear on any day which is convenient, my lord.
Yes, definitely.
It is in the original site, my lord.
Original side. Original side, I think Wednesday we will take up.
Yes.
Wednesday, second half.
Great.
Lordship, may I leave to mention for the filing of the memo of appeal on the Group 9 application, the order was passed on 29th August 2024.
Server copy is available?
With server copy.
Yes, leave granted.
Lordship, may I be permitted to mention for upgradation, Lordship, this petitioner is without electricity, applied before the CSC authority, and they are not giving the connection, Lordship. I'm praying for upgrade.
What happened to your writ petition? It was dismissed.
Lordship?
What happened to your writ petition?
There was an order passed by the learned ombudsman. We have challenged the order before the single bench. The writ petition has been dismissed, challenging the said order.
All right, you give. Let us see whether we can do it before vacation.
Grateful.
My lord, I'm so sorry, my lord. I'm tendering my apology. My lord, that was an appellate side matter, not the original side matter.
Appellate side matter, I think it will come day after or tomorrow. The court officer will tell.
I tender my apologies.
No.
My lord, may I have your lordship's leave to mention, my lord, for upgradation, my lord, due to pendency of this matter, my lord, the society work was stopped. So,
Okay.
my lord,
What is it's running in the monthly list?
my lord, it's running in the list.
Lord, leave to file an intra-court appeal with the server copy, my lord. I have applied for the certified copy. Order is dated, my lord, 3rd of September.
All right, leave granted.
May I be permitted to mention item 82 and 83 of your lordship's leads? This is a leave to appeal filed by the colonel of an army, and between wife, your lordship can remember 2 daughters appeared before your lordship.
Yes.
This matter was referred to the mediation failed, returned back to your lordship. Now, there was a request from your lordships not to proceed in the lower court. Now, for 2 children, one is reading at class 8 and another 6. He's paying only the maintenance towards daughter 40,000 per month, but he is not paying any educational expenses as was directed by the...
You're mentioning upon notice?
I have intimated, my lord. I shall again serve notice if your lordship so desire.
No, then we will list it under the caption to be mentioned on the next day, earliest date. On that date, let them appear. Then we will see what can be done.
Yes, I shall serve notice to.
My lord, may I be permitted to mention, my lord, upon noticing the other side, my lord, and the appeal application has been filed in the year January 2023, my lord. Till now, it is, my lord, it is challenging against some inactivities of the Pradhan. My lord, appeal has been filed.
All, please give.
Give
the letter. Yes, please call.
Matter from the regular list. Item number 1.
My lord, item number 1, I beg to appear for the petitioner.
We dismissed your writ petition.
My lord, this was that matter in which I was constrained to appear online due to some technical irregularities. My lord, dismiss the petition. My lord, I did not take out a recalling application pursuant to...
What is the prayer you want?
Yes. My lord, kindly, my lord, take notice of the fact that, my lord, the total student strength of the school in question is 480. Now, my lord, each and every day, my lord, 110, 130, sometimes 40 students are appearing in the school, are coming to the school. They are being fed as per the midday meal scheme.
Very good.
My lord, but the billed amount, what is in the portal, is somewhat around 400 students per day, 300 students per day. May I please your lordship, my lord, kindly comes to page number 24 of the writ petition. Pagination nahi kya? My lord, kindly sees, my lord, that's in Bengali though. My lord, the total number of students in the month of March 2024. And this is not from my personal record. This is from the record of the self-help group who cooks there, who maintains a record as to the number of students who are being fed. My lord, in the month of March 2024, at the bottom, my lord, it's indicated that the total number of students being fed is 1819. My lord, comes to the very next page. The very next page, my lord, indicates the number of students who are being fed. My lord, indicates the number of students who are being fed that is uploaded in the online portal. My lord, comes to the last. My lord,
But then, sir, this petitioner, in fact, on the last occasion, based on the complaint given by the petitioner, the sub-inspector of schools, Suri Central Circle, had made an inspection and he had submitted a report. In that, there is a report says that the petitioner wanted to be the second teacher through a resolution, but there is no such provision in a primary school. And the petitioner and others agreed that Gopali Chat as the joint operator with HT, head teacher Amla Ballal, and made the resolution of the same. But since after that, Amitav Roy raised objection in this ground in all respects. Amitav Roy was making videos and photos regarding MDM and classes, even in the classes of female teachers, which is annoying the female teachers. Petitioner has been continuously creating objection and non-cooperation with HT and Gopali Chat, joint account operators, and sometimes shouted so loudly that made the staff room atmosphere very unpalatable. And as per the written and verbal statement of Amal Ballal, who is the head teacher, before joining as head teacher, Amal Ballal received continuous threat from the petitioner regarding the matter that choice of school as head teacher, and there will be only one person who will be head teacher of so-and-so, and it's none other than the petitioner. Considering the above and after discussion with all the teachers, it is observed that the school environment was not healthy for proper education due to the unacceptable behavior and unusual activity of the petitioner. After long discussion with teachers, petitioner was also asked to come to school over telephone by the undersigned, and he came there also. It told the undersigned to make all kind of cooperation so that the school can work as a proper education institution in all respects. Therefore, in fact, on the day when the inspector visited the school, your client was not present. There is some internal dispute. We cannot entertain it at your instance. Therefore,
my lord, may I humbly indicate? My lord,
your client is creating ruckus in the school, sir. He is filming the videos of classrooms where female teachers are there. What is all this?
My lord,
sir,
you are
part of the same school. We will dismiss it with cost.
My lord, may I indicate one small thing, my lord? Everything else is said, but the allegations of the writ petition are not mentioned there.
All right.
Everything else is important, my lord.
Yes. We have heard
this. That I asked myself.
Yes. We will deal with that. This writ petition was filed by a teacher as a public interest litigation, alleging certain malpractices in the midday meal scheme in a particular school. The fact remains that the petitioner is also working as a teacher in the very same school. The allegation was, though the student strength was at a particular level, the number of students who attend the school regularly was much lesser than the total strength. However, in the midday meal scheme records, it has been shown as if food has been provided to all students, including those students who were not attending or were absent on a particular day. This appears to be the genesis of the entire complaint made by the petitioner. The sub-inspector of schools, Suri Central Circle Birbhum, has inspected the school and submitted a report to the chairman of the Birbhum District Primary School Council, dated 1/8/2024. From the report, it is seen that the petitioner has been creating several problems in the school, and there is also an allegation that he has been taking video and photographs regarding the midday meal scheme and classes where female teachers were teaching, and there has been constant problem, and the head teacher has also made a complaint stating that he received a continuous threat from the writ petitioner. The learned advocate for the petitioner would vehemently contend that in the report submitted by the sub-inspector of schools, there is no whisper about the allegation made by the petitioner regarding the midday meal scheme. Firstly, we need to point out that the petitioner, being a teacher in the very same school, and there being certain internal disputes, we cannot consider this as a genuine public interest litigation. Rather, it is motivated for certain other reasons. Therefore, we cannot entertain the prayer sought for in the writ petition. However, it goes without saying that the sub-inspector of schools, namely the third respondent and the fourth respondent, shall conduct an audit as to whether the midday meal scheme is properly implemented in the said school.
My lord, in the report, my lord, the first point and fourth point deals with midday meal.
Though in the report submitted by the sub-inspector of schools dated 1/8/2024, there is a mention about the manner in which the midday meal scheme is being implemented, we would only observe that the chairman of the Birbhum District Primary School Council shall also take a look into it as to whether the scheme is being properly implemented. Thus, with the above observation, the writ petition is dismissed. In the first paragraph, sir, you please take down. When the writ petition was listed on 29/8/2024, the learned advocate for the petitioner appeared online, and after taking into consideration the report filed by the sub-inspector of schools, the writ petition was dismissed. Subsequently, the learned advocate for the petitioner mentioned before this court, stating that during the online virtual hearing, due to connectivity issues, he could not make his submissions properly and therefore wanted the matter to be heard afresh. Based on such submission, the matter was directed to be listed under the caption to be mentioned, and it is so listed today.
My lord, one small interruption. My lord, I do not have the copy of the report. My lord, majorly the report brings in new facts, my lord, which are not pleaded in the writ petition. May I be handed over a copy of the report and an opportunity to file an exception to the report, my lord?
All right. After we have dictated the order, the learned advocate for the petitioner would continuously submit that the copy of the report should be furnished to the petitioner, and the petitioner should file an exception to the report. As observed earlier, we find that the writ petition cannot be a public interest writ petition. It is clearly motivated, and the petitioner has certain mala fide intentions behind filing the writ petition. Therefore, the writ petition is not only dismissed, but dismissed with cost of ₹25,000 payable by the petitioner to the West Bengal State Legal Services Authority within 30 days from the date of receipt of server copy of this order. Next.
Extremely grateful.
Intra-court residuary appeal for admission, item number 2.
Lordship.
Yes, madam. What is this?
My lord, I have filed this appeal application because I didn't got any further order. Only I've got the order for armed picket. The order was extended for armed picket, but there was no direction for the authority. And the respondents were created problem, and still torturing us and giving fabricated case, and police are making fabricated cases in behalf of...
No, you filed the writ petition about 2 years back.
Yes, Lordship.
Stating that somebody was playing drums, etc., and causing you some harassment. As in a writ petition, we cannot give you a blanket protection, no?
My lord, in the read petition, Justice Jay Sengupta has provided arm picket, and the order was, and after that, the next order was passed on 20th January 2023, and the Justice Mantha has extended the arm picket, the order for the arm picket for 1 month, but there was no direction for the authority, respondent authority to stop the, I mean, police has submitted the respondent for, he is insane. If he is insane, it doesn't mean that he will create problem in my life. And he is absolutely okay, my lord. I have filed a can petition, can 2, that will show you the pictures. He is absolutely normal. And I have given in can 2, page number 21, my lord. Have given a complaint letter challenging the order to the medical authorities, that he is absolutely okay, and the order has been, and they have submitted the report that he is 90% insane.
Then who is that person?
He is 21-year-old boy named Aftab. In can 2, I have attached the pictures also, my lord.
No. See, if there is a complaint lodged by you against this Aftab and action has not been taken, you have to file a petition before the magistrate. Or if no action is taken, under the code, there are several remedies. Under the new laws, there are several remedies. In a writ petition, we cannot go into. He will come and say that I am mentally not well. How can we decide that in a writ petition?
My lord, he is, if police authorities are helping the, respondents, private respondents to create problem, not, they are, all the private respondents are occupying our space. They are blocking our gates.
All right. Now we will give you liberty to approach the police by way of a fresh complaint, which can be looked into, because this is more than 2.5 years old. And the appeal was filed somewhere in 2023, and it was moved. It was not moved. And lastly, it was heard on 14/3/2023. Then thereafter, nothing happened, and only listed on 8/7/2024. All right. This intra-court appeal by the petitioner who is appearing in person is directed against the order passed by the learned single bench in WPA 27265 of 2022, dated 21/2023. The petitioner seeks for certain relief against the private respondent and disputes the stand taken by the police that one of the private respondent, namely Aftab, is mentally unsound. Firstly, the matter is more than 2 years old, and it is not clear as to what is the present situation. Therefore, we dispose of this appeal, giving liberty to the petitioner, who is appearing in person, to approach the concerned police by way of a fresh complaint, if still the problem she is complaining of persists.
My lord, give me some time. My lord, I have filed a can petition too. Just kindly see can 2.
We saw that. That is what we are saying. We don't want to.
Police authorities are not at all taking care of my complaints. They are just suppressing my complaints, my lord.
All right. Next line you add. It is needless to state, if a fresh complaint is lodged by the petitioner, the police authority should proceed to take action in accordance with the law on the said petition, on the said complaint. Yes, next.
Item number 3.
May I
Your
please?
lordship, I appear for the writ petition.
May I please, your lordship, my lord? My lord,
Yes.
this appeal at the BSW West Bengal State Electricity Distribution Company Limited. My lord, prior to that, my lord, there is some delay. Your lordship, kindly, my lord, contact. My lord, what has happened? The learned single judge, by passing the impugn order, my lord, the set aside and coerced the order of the grievance redressal officer as well as the ombudsman. The ombudsman, my lord, passed an order directing us to regenerate. What has happened, my lord? The potential transformer was defective. On inspection, it was found.
It
Well,
was never inspected.
my lord,
Never.
subsequently, my lord, the bill was regenerated. On the basis of the previous year's consumption, your lordship knows, my lord, as per regulation, there is a provision 3.6.1 that
All
he-
right, we'll entertain your appeal because the appeal had to be heard in finally.
my lord. But my
All
lord,
right.
the contempt proceedings was there. Your lordship's kindly, my
No,
lord.
no, there can't be any stay. The learned judge just quashed the order and has
Yes.
said that no further amount need to be
Yes.
paid. Where is the question of stay? If by granting a stay, obtaining a stay, you cannot seek to recover. You
Yes,
have-
my lord. After that, my lord, we have not taken any steps. We have
Ah,
not regenerated the bill also.
okay. The appeal is admitted
My
for
lord, may I
hearing.
say, my lord, may I say, your
Ah.
lordship kindly sees the order, impugned order was passed on 13th March 2023. My lord, from and this instant appeal, MAT was filed, my lord, the memorandum of appeal was filed on 6th July 2023. Till date, till 16th of August, my lord, after the contempt court had passed an order directing them to file, my lord, an affidavit of compliance, my lord, that they have praised this appeal before your lordship after a period of 1 year, 1 month.
My lord, that my lord,
They have just filed an appeal.
my lord, may
It is
I clear to your lordship, my lord?
That is improper, sir. That is improper.
My lord,
See,
may I complete?
if you are serious, you should have moved the appeal
But
immediately.
Yes, my lord, he kept
clear
it
to your
pending
lordship,
for
my
1
lord.
year, 1
I
month.
am not filed the appeal.
It is-
Initially, appeal was filed by some learned advocates.
No, my lord, they
Maybe.
were present. They were
Actually-
present at the time of hearing. What are you saying? My
Rajkumar
lord,
Basu.
4 days it was heard, my lord.
Rajkumar
4
Basu,
days.
my lord, kindly consider the learned advocate, my lord, after filing the appeal, my lord, somehow he has, my lord,
My lord, there is a delay of
retired
85
from
days.
from
And
the
no ground has been stated, my lord, condonation of no reason cited for condoning the delay. Nothing, your lordship kindly
Where
sees.
is the section 5?
Yes, my lord, paragraph 9.
My lord,
10.
sees, my lord, paragraph 9. Kindly sees the petitioner says that the petitioners, after going through the order, decided to file an appeal against the order and took the action for which
Sorry,
some
sir,
time
this-
has been taken.
Ah.
They were present in the hearing. They were present throughout, my lord. At the
All
date
right.
when the order was pronounced, they
Sir,
were also present.
cancel the previous order takedown. This intra-court appeal by the West Bengal State Electricity Distribution Company is directed against the order dated
13th March, your lordship.
Wait.
My lord.
Order dated 13th March 2023 in WPA number 178/28 of 2019. The appeal has been filed beyond the period of limitation, and there is a delay of 85 days in filing the appeal. Under normal circumstances, the court would have exercised discretion and condoned the delay, as it is only 85 days. But however, we have taken note of the conduct of the appellant in the manner in which they have proceeded to pursue this appeal. The order passed by the learned single bench is dated 13th March 2023, and the appeal was presented before this court on
6th of July 2023.
6th of July 2023.
Yes.
And 6th of July 2023. But without an application under Section 5 of the Limitation Act to condone the delay. This application in Can 1 of 2023 was filed subsequently. On perusal of the application, we find that the only reason which has been stated by the appellant is in paragraph 9. On going through the said paragraphs, we find the averments to be completely vague, bereft of any particulars and details. The reason for moving the appeal at this juncture by the appellant is on account of the fact that a contempt application has been entertained, and the contempt application entertained by the learned single bench, and the matter was heard, and there was a direction issued to the appellant herein to file affidavit of compliance of the order and direction issued in the writ petition.
Sorry, my lord, no compliance, affidavit. Only direction for filing affidavit.
All right, direction was filed to file an affidavit by the appellant. It is only thereafter the appellant appears to have taken steps to move this appeal before this court.
My lord, kindly consider.
In any event, in any event, the appellant, which is a wholly owned government concern, government company, having not explained the delay, we are not inclined to exercise any discretion. Accordingly, the application for continuation of delay is dismissed and the appeal stands rejected. Next.
Deeply obliged, Your Lord. Item number 4. 4, my lord, I am for the appeal.
I am for the state, Lordship.
My lord, first of all, my lord, I will invite your lordship to come to the last annexure, my lord. This is the guideline, my lord, how the issue should have been dealt with. This appellant, they are the cook cum helper of a Madhyamik Shiksha Kendra. And my lord, a group of people, rather the group of politically motivated people, and most of them, my lord, the relations of the head of the institution, my lord, they brought an allegation that the quality of food cooked by this group of people, group of cook cum helper, is not good. With this allegation, and a proceeding has been initiated and we are removed. Your lordship, kindly see what is the mandate, what should have been done by them, and what is the concern, my lord, expressed by the state government, my lord, to this effect. If your lordship kindly turns to last annexure.
No, before that, can you show the order of removal?
My lord.
You have not challenged that. Order dated 4th July 2019.
Yes, I have challenged it.
Page.
My lord, this is in page 68. All local governance, my lord, they dealt with the issue, and all are, my lord, filled up by the group of people of this, my lord, head of the institution. My lord, secretary is from his family. The other staffs of the institution, they are from his family. The prodhans are from his, the prodhan is from his family. My lord, now these. Now, my lord, this was a matter of concern of the state government, and that is why a specific order was passed, or rather given, my lord, which is appearing in page 86. My lord, my point is that, my lord, there is a specific direction that before dealing with all such issues, inspection by the district level committee should have been done. They avoided interference.
One thing. Now, inspection cannot be done because at that time they tested the food, etc., took note of the complaints and taken a decision. Now, this order was passed by the BDO, Block Development Officer, sometime on 4/7/2019.
Yes.
From 2019, another group or another self-help group is functioning. At this juncture,
well, they can be removed at any time.
Permissible. There should be some
lordship kindly sees, only lordship kindly sees, this is the injustice I am facing. I am the victim of the political interference, and there is a specific shield for me. That is a mandate for the authority to be complied with. If your lordship kindly sees the second last paragraph of the memo I am referring to in page 86.
Yes.
This happens, and that is why that was the direction. In the cases of allegation against cook cum helper, proper inquiry should be held by the district administration before taking any steps. This had not been followed. What they have done, they have invited the pradhan, who are their man. They have invited the secretary, who is their man. All local governance, they invited. They prepare a report from everyone, and I mean, what is the method? How they have come to the conclusion that the quality of food? Mere saying that the quality, it may be a tasty food for anyone, but may not be for me. And how they have decided? What is the procedure? What is the method? Nothing. No method is established.
No notice was given. Show cause notice.
No, nothing.
Now, in this writ petition, have you implemented the new self-help group?
I don't think so, my lord.
That's the problem.
No, my lord.
And my instruction is that the new self-help group, their account has been frozen. Their account has been.
That is not the case, my lord. Let him place his case.
Yes, they are proceeding against them, but they are not disclosing it here.
But then,
they win here. They will
No, no.
proceed with their illegality once more.
Let me confine to the impugned order only, my
Let
lord.
them
That
say
is
that
all.
their account has not
Impugned
been
order, my
frozen.
lord, it has been categorically
They
held
knows
with
their,
regard to that
their
30th
guilt.
August
They knows their
2019, my
guilt.
lord.
They have frozen the account.
Everything has been
And now they
discussed.
are not disclosing it.
No, no, wait, one at a time. Who's the 13th respondent in the writ petition?
My lord, may I?
You take the certified copy of this.
My lord, this is the new self-help group. My lord, what
You said they are not implemented. What is all this, sir? All right, please come. This intra-court appeal by the writ petitioner is directed against an order dated 27/2022 WPA 160/87 of 2019. In the said writ petition, the appellants who were engaged for cooking the midday meals
for last 18 years.
For the past 18 years was removed, and the 13th respondent was appointed in the place of the petitioners by the order of the Block Development Officer, Karimpur Roman 2 Development Block, dated 4/7/2019. This order was put to challenge in the writ petition. The writ petition was dismissed or disposed of. The writ petition was dismissed by the impugned order. We have heard the learned advocate for the appellant and the learned government counsel appearing for the official respondents. Assuming that there were certain allegations against the petitioners with regard to the quality of the food prepared in the midday meal program, the government of West Bengal School Education Department has laid down a guideline-wide memo dated 30/8/2019 as to how such allegations have to be dealt with. In the said memorandum, it has been stated that in the case of allegation against any cook cum helper, proper inquiry should be held by the district administration before taking steps. It is an admitted fact that there was no show cause notice issued to the petitioner, nor any opportunity was granted. The petitioner has made serious allegations against the Pradhan and others, and submitted that they all form a single group and have targeted the petitioners who had been functioning for the past 18 years only with a view to help the 13th respondent. Perusal of the impugned order, it is seen that notices were issued to the management committee of the school and others against whom the petitioner has made serious allegations. And it appears that all of them, in one single voice, have supported the 13th respondent. In fact, a reading of the order dated 4/7/2019 it shows that the specific allegation against the petitioner has not been pointed out. The written statements of the Pradhan and the written statement of the members of the 13th respondent, etc., has been referred to, and the block development officer states that considering all aspects and for well-being of students of the said Kendra and smooth running of the midday meal program, the 13th respondent is engaged as cook cum helper in the said Kendra. Thus, it is seen that no specific allegation or mismanagement has been pointed out against the petitioners to replace them by the 13th respondent. That apart, in terms of the guidelines issued by the government dated 30/8/2019, the district administration should have conducted a full-fledged inquiry, which appears to have not been done, as the order has been passed by the block development officer. Therefore, we are of the view that the order removing the appellants from the post of cook cum helper has to be set aside. However, we are conscious of the fact that the order was passed in the year 2019, and from 2019, the 13th respondent is said to be functioning. And if at this juncture, the 13th respondent is removed or dislodged, then the ultimate sufferers will be the students. The learned advocate for the appellant would contend that the 13th respondent has committed various misdemeanors and his account has been frozen. However, there is nothing on record to indicate so. In the light of the above, we direct the district magistrate Nadia to conduct an inquiry into the matter, as the petitioner alleges. The petitioner has made serious allegations against Pradhan and others, and submitted that there is a big cartel. The district magistrate should inquire into the matter, either by himself or by appointing a senior and efficient officer to conduct the inquiry. In the inquiry, notice should be issued to the appellants as well as the 13th respondent, the Pradhan and all other concerned, and a fresh decision be taken in accordance with law. Till then, whatever is the status quo which is prevailing as on date shall continue. In the event that the 13th respondent has been suspended and the authorities have made alternate arrangements, the said alternate arrangement shall continue to prevail till a decision is taken by the district magistrate. The above direction be complied with within a period of 2 months from the date on which the server copy of this order is received by the office of the district magistrate. Next.
Grateful.
Item number 5.
I am for the appellant. I am for the Respondent Union of India led by DSG. My lord, this is an appeal against a judgment passed by Honorable Justice Hiranmay Bhattacharya sitting in the seat.
This appeal is directed against an order passed in a writ petition by one of us, within bracket, Honorable Justice Hiranmay Bhattacharya. Hence, the matter is released from the list. Papers be placed before the Honorable Chief Justice for appropriate orders.
Grateful, Lordship.
Item number 6.
May it please the Lordship, my lord, I appear for the petitioner.
Very good.
Led by Mr. Obrotos Mujumdar.
I beg to represent the state in this matter, Lordship.
Yes, sir.
Now, this is an intra-court mandamus appeal arising out of an order made by the Honorable Single Judge, my lord, on the 19th of June 2024. Whereby, my lord, our writ petition, which was presented by us to dismiss, my lord, on the ground, my lord, the ground urged in support of, there were a number of writ petitions, I must tell you, Lordship, and one of the orders, my lord, fell for consideration before my lords at some point of time previously, and the matter travelled to the Honorable Supreme Court at the instance of some other party. Your Lordship, kindly come to the memorandum of appeal. My lord, in the memorandum of appeal, your Lordship, please to find, my lord, Annapurna Medicine Distributors, my lord, it carried an appeal before your Lordship's court, my lord, and from that, an appeal was preferred before the Honorable Supreme Court. The Supreme Court remitted the matter back to the Honorable Division Bench, my lord, for consideration. That order is also a part here. My lord, by filing the present appeal, my lord, and a connected application, my lord, I am being led by Mr. Mujumdar, my lord. Mr. Mujumdar is here.
Please come.
Let him take over, my lord, kind.
My lord, may I just indicate to your Lordship the broad issues which arise?
So, the other appeal,
yes.
When is it listed?
My lord, it is yet to be listed, my lord. There is a request from the Honorable Supreme Court whether that matter can be listed expeditiously.
Where is
subject
the
to-
order of the Honorable
There was
Supreme
a
Court?
liberty to mention, my lord, in the
Malad,
last
liberty
order,
to mention,
last
Malad,
order by your
Malad,
lordship.
Nobody
may I just-
mentioned to us.
Lordship.
Yes.
Malad, we will, has it been mentioned?
No.
Malad, yet
Nobody
to
has
mention.
mentioned, sir.
Yes,
But
yes, yes.
at least
Malad,
somebody
I will
should
lordship.
bring it.
Malad, may
See,
I just
somebody should
indicate?
bring it to our notice. No,
Yes, yes, I'm
ultimately,
I'm so sorry,
what will
Malad.
happen is you will all go and blame us there.
No, 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 no,
saying
no,
that the
no,
High Court
no,
has
no, no,
not
no,
taken.
no, no,
No,
no,
sir.
no, we are the last persons, Malad. We will never do so. But Malad, it is yet
We
to be
don't go by
mentioned.
statements, sir. Anymore, we don't go by
Malad,
such statements.
Malad, the Supreme Court order is at page 432.
Volume 2.
Volume 2. But this is a case where, my lord, the tender process 432.
This order was made on 29th of July.
Sir, yes, sir, SLP has been dismissed, sir.
Yes, yes.
And if they have not moved, what can we do about it?
No, 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 no. My lord, may I just indicate to your lordship, in this SLP, in this appeal, the specific point taken was that of, my lord, cartelization, formation of cartel.
No, it is against an interlocutory order.
It is against an interlocutory order.
All right, please show our order dated 8/7/24 in CAN
Right,
1
right.
page.
When the stay order was deprecated by your lordships.
My lord, may I just indicate to your lordship, my lord, in my application, 1 minute, in my application, my lord, we have annexed several documents to demonstrate before your lordship, not only, my lord, the tender process was vitiated by price rigging, by, my lord, cartelization, but also, my lord, some of the tenderers, successful bidders did not fulfill the minimum eligibility criteria.
Not these points were not
My lord, I
taken
tell
into
your lordship, this is such a case, my lord, where, my lord, I tell your lordship, the entire process has been subjected to malafide, vitiated by arbitrariness, and, my lord, vitiated by pick and choose policy.
Sir, one small question. Sorry to interrupt.
I'm so sorry, my lord. I'm so sorry, my lord.
The writ petition was filed and interim order was granted. I think the state filed the appeal, or whether interim order.
Absolutely, 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 absolutely.
State filed the
Yeah,
appeal.
one of them filed the appeal, lordship.
And one of somebody,
State filed
I don't know. Somebody filed the appeal.
Yes.
And we allowed the appeal and vacated the interim order by order dated 8/7/24. Correct?
No.
My lord, it is the disposal of the writ petition, or the writ petition was disposed of. A batch of writ petitions were heard and disposed of by the Honorable Single Judge. Against the final judgment and order, we came up before your lordship.
10 June,
My lord, on 10th June 2020, your lordship may be referring to the order dated 10th June 2024.
8th July 2024. That was the order which was challenged in Supreme Court.
That's the final order. That is from the final. Yes, my lord, it's from the final judgment and order. It's from the final judgment and order.
No, sir. Please read, sir. Please read page 432. The special leave petition is directed against an interlocutory order.
Absolutely, interlocutory
Passed by
order,
your
my lord.
Which is passed by your lordships.
denying
In
the
the pending appeal, but
May I just
deprecated the stay
indicate,
order.
my lord, may I just indicate, it is, my lord, the interlocutory at the
thing is that as
interlocutory
far as
stage, your lordship was pleased to decline to pass any interim order. That this is that interlocutory appeal which was carried to the Honorable Supreme Court.
Please show our order, sir. Please show our order.
My lord, your lordship, my lord, may I read out your lordship's
In the
order?
paper book, you
8
please
July
show.
order.
It is not there, my lord. May I just read out, my lord, subject to your lordship's kind consideration. We have heard the learned advocates for the parties. This is an intra-court appeal by one of the unsuccessful writ petition in a batch of cases. The writ petition after contest has been dismissed. The learned government pleader submitted that the tender has been finalized and work order has been issued in favor of the private respondent, and the agreement is to be signed shortly. Considering these facts and the appellants also being participants in the tender and having been unsuccessful, this court is of the view that an interim order cannot be granted at this stage, as the writ petition has been dismissed on contest and the correctness of the order can be decided only at the hearing stage. Apart from that, any interim order will be against public interest. Therefore, the prayer for stay is rejected. Accordingly, IA so and so is dismissed. It is made clear that all steps taken will be subject to the result of the appeal.
Liberty to mention.
Lordship's order.
Liberty to mention for inclusion in the
This is
list.
MAT 1260.
This is MAT 1260, but as referred to, your lordship will find the same MAT number.
All right. List along with MAT 1260.
Yes, MAT
Very
1260.
well, very well. Day after tomorrow.
My lord, kindly keep it at a short date, my lord. I tell your lordship, the difficulty in this case is that, my lord, though they have issued work orders.
Once again, sir.
Yes.
MAT 1260.
Yes.
Lord, that MAT number is not in the SLP.
MAT 1260, my lord, is over the same issue, my lord. So let all the appeals be taken up together.
But that I agree, my lord.
All right. In this appeal, FMA 951 of 2024, this appeal, the unsuccessful writ petitioner has challenged the award of tender in favor of the private respondents. Along with the appellant, there were other writ petitioners as well, and the writ petitions were dismissed after contest. One of the appellant, one of the writ petitioners,
That is WP number, my lord, 12967. Kindly have a look at the impugned judgment, lordship, in the memorandum of appeal. 12967 was the appellant before your lordship.
Yes, Mr.
That is of 2023.
Yes. 1267.
12967
was the appellant before your lordship.
One of the appellant, writ petitioner, namely Annapurna Medicine Distributors, the writ petitioner in WPA 12967 of 2023 filed an
2024 lordship.
2024 filed an intra-court appeal in MAT number
1260
of 2024.
1260, my lord.
1260 of 2024, in which can number 1 of 2024 was filed praying for appropriate interim orders.
Stay order, lordship.
Praying for an order of stay of the impugned judgment. By our order dated 8/7/2024,
8 July, lord.
8 July, my lord. 8 July.
8/7/2024. The prayer for grant of interim order was declined and the stay application was dismissed. Challenging the same, Annapurna Medicine Distributors filed appeal before the Honorable Supreme Court in special leave to appeal C numbers 16221 of 2024, and by order dated 29/7/2024, the Honorable Supreme Court declined to exercise jurisdiction under Article 136 of the Constitution, and the special leave petition was accordingly dismissed. In the said order, the petitioners therein, namely Annapurna Medicine Distributor, were given liberty to move the bench, within bracket this court, for expeditious disposal of the latest patent appeal. Till date, the said petitioner had not moved this bench, nor moved this court, nor this court is aware about the order passed by the Honorable Supreme Court, which is placed before us for the first time in this appeal. In the light of the order dated 8/7/2024, declining to grant an order of stay at the instance of one other writ petitioner, who was also the writ petitioner along with the present appellant, and the said order passed by this court having not been interfered by the Honorable Supreme Court, the question of granting an interim order in this appeal would not arise. Accordingly, the stay petition is dismissed.
So, my lord, this is not a stay petition. My lord, this is not a stay petition. My lord, what we are praying before your lordship, subject to your lordship's kind consideration, we are praying, my lord, we have annexed certain documents to demonstrate that ineligible tenderers have been given the work order. So, my lord, those documents are to be taken on record. My lord, there is a specific prayer made in the application.
My lord, I am objecting to that.
My lord, that prayer,
I want to file my
let me
objection
file
to that, and
My lord, may I
let
just-
that be heard first.
There is no prayer for stay.
No. There is no prayer for stay.
No. What is Can 1 of 2024?
Lord, kindly cease. The prayer is
My lord, I have objections to this.
Wait, madam, please wait.
Yes.
prayer 24.
Then the last line you delete, and therefore the question of grant of any interim order of stay in this appeal would not arise. And presumably the appellant, being aware of the same, has not filed any stay application. Can 1 of 2024 has been filed by the appellant praying for
My lord, liberty to rely on the facts stated in paragraph 10 to 61 of the.
Please, sir. To praying for leave to rely upon the facts stated in paragraphs 10 to 61 of the application, along with documents in support thereof, annexed thereto, at the time of hearing the appeal being MAT 1330 of 2024, semicolon, for appropriate orders to direct the respondent authorities not to take any coercive measures against the writ petitioner, against the petitioner / appellant pending MAT 1330 of 2024. So far as the first prayer is concerned, the learned advocate
I will-
appearing for the respondents would vehemently oppose the prayer.
I want to file
We heard you, madam. Please, if you start giving running commentary,
sorry.
it's very difficult, madam. My language
apologize,
is
my lord.
my language is not as good as you. My English is not as good as yours.
Absolutely not. That's not the case, my lord.
I vehemently oppose the prayer and seeks leave to file an affidavit in opposition. Leave to file affidavit in opposition be as granted, and the same shall be filed within a period of 4 weeks from date. Reply, if any, within 2 weeks thereafter. So far as the prayer B is concerned, as indicated above, the appellant seeks for direction upon the respondent not to take any coercive measure. This appears to be in the nature of nature of an order.
We are not pressing prayer B, my lord. It will be recorded.
This being in the nature of an order, which would indirectly amount to a prayer for stay, we were inclined to dismiss such a prayer, and the learned senior advocate appearing for the appellant on instruction submitted that prayer B in Can 1 of 2024 is not pressed. Accordingly, the same stands dismissed as not pressed.
Mr. Majumdar, only one thing. If you in relief in prayer A,
prayer B, my lord, prayer B.
Prayer A, you wanted some additional facts to be taken note of.
Right.
That can be only by way of an amendment of the writ petition. How can you bring in additional
This is
facts?
in the nature of Order 41, Rule 27, my lord.
No, Order 41, Rule 27 is additional documents, not additional
documents.
pleadings.
Only the additional documents may be taken on
But
record.
you have said, but your prayer is to rely upon facts stated in 10 to
absolutely,
61.
my lord. Only, my lord,
And there is a lot of facts you have stated in paragraph 10 to 61. Unless without amendment, how can you bring these facts?
So, my lord, let the maintainability of the petition be kept up.
My lord, may I just indicate to your lordship, my lord, we will rely on the documents which have been brought on record by way of this application. My lord, we will confine ourselves to those documents only at the time of
not
hearing.
The facts. Not the facts.
Not the facts, but whatever documents we will rely on, obviously we will make submissions on those documents.
No, sir, this is going to drag on the problem. Now, when they file their affidavit in opposition, they will raise this as a first objection.
Yes.
See, now the form of the application is not proper. Please accept that. The form of the application is not proper. So, therefore, either you need to amend it or withdraw and file a fresh application.
And fresh documents, Mr. Majumdar, only also one thing.
Yes.
Fresh documents, without there be any basis in the pleadings, how can you be permitted to place those additional documents if there is no basis in the pleadings?
My lord, we will file a, my lord, in that event, my lord. I would beseech your lordships that in the facts and circumstances of the case, we can rely on the documents first and then proceed, my lord. We can file
No, sir. Probably the client is becoming wiser after the writ petition is dismissed.
Yes.
So you better withdraw Can 1 of 2024 and file an appropriate application seeking leave to raise, because you have to plead and prove.
Yes.
If there is no supportive pleading, how will you rely on the documents alone?
My lord, we have made supporting pleadings in this application.
Prayer is not like that, no, sir.
My lord, prayer is there, my lord, 45 to 60.
All right, let this order continue, madam. You file your affidavit.
My lord, only one submission, my lord. My lord, taking cue from the observations made by my lords. May I just, my lord,
no, let them think over and decide. Not
my lord, only one submission.
Lordship, may I pray for one line in the order,
my lord, only one
the
submission.
maintainability of the interlocutory application be kept open.
All right. The learned advocate appearing for the state submitted that the state also will file an affidavit regarding the maintainability of the application. Leave is granted to the state to file their affidavit in opposition within the same time frame as given to the private respondent. The maintenance of the application will be decided upon after the pleadings are completed.
My lord, only one submission, my lord. Your lordship has posted this matter 4 weeks affidavit in opposition for 2 weeks reply.
6 weeks.
My lord, 6 weeks. My lord, may I just indicate to your lordship, though work order had been issued in July or June 2024, my lord, since yes, my lord, the learned government pleader may nod otherwise, but it is so that till date, since these people are incompetent, they don't have the expertise, they don't have the infrastructure, my lord, we are still continuing, and they're still continuing with us.
All right. CBI is investigating, sir. Let it investigate.
No, it is not that case, my lord. This is FPMS.
Next.
Started
This is
operating.
not biomedical waste.
We have started.
Item number
operating.
7.
No. We will know by today evening.
My lord, only a shorter date. That is all I pray. Only a shorter
Your Lordship, the memo was filed in the month of July.
date.
And they have
Vacation is
filed
going
this
to
approved
Now only
application in
they
the
have
month of
engaged
September.
Mr. Bhattacharya and Mr. Mazmundar. They have engaged them only now. What to do?
Lordship.
Next, sir. Sorry, sir. Next.
Item number 7. Your Lordship, I beg to appear for the petitioner. Your Lordship, this is a leave to appeal. May I place can 2? That is my leave to appeal. Now, why I have been constrained to file this leave to appeal? Your Lordship would first take page 36, the pleading of the writ petition at paragraph 7. My Lord, their contention is that is with
Who are you,
relation.
sir? Who are you?
My Lord, I am an admitted co-sharer and I had instituted a civil suit for partition. And
You file a review. You file a third-party review before the court. We cannot test your case. That will be better.
No, difficulty is this, my lord, I have not been impleaded as party in this.
Sir, you file a petition before the concerned court to leave to file review. That is where you can bring court of first instance. You place the facts. We can only test the correctness of the order here on what is said. But you have to bring fresh facts, fresh documents.
But these facts were already on the writ petition. That is my case before.
All right. We will give. This intra-court appeal is by a third party who has sought leave to file this appeal on the ground that the applicant, the petitioners are co-sharers. In our view, since facts are involved, if the appellant should first approach the learned writ court by way of a third-party review application if they want to bring their factual position on record, which will be tested by the learned writ court. Accordingly, the appeal is disposed of by granting leave for the appellant to file the review application before third-party review application before the learned single bench. Since this appeal was presented before this court on what date you presented
it? 15th of July 2024. We are preferred.
July 2024. And the appellant having not been made as a party, the learned single bench may consider these aspects while considering the application for continuation of delay.
Highly appeal.
I appear on behalf of the state.
Yes. Next.
Item number 8.
I appear for the respondent, Bank, Your Lordship.
I'm for the petitioner appellant. I'm led by Mr. Mitchell.
May it please your Lordship, my lord. If your Lordship comes to the impugned order, it passed on 12th June. Your Lordship will kindly come to.
In fact, sir, last occasion,
yes,
we had passed an order on 31st July 2024.
Yes.
To the effect that the court observed as to whether on account of the changed circumstances, the writ petitioner still wants to pursue the writ petition.
But in this matter, I don't think so.
Oh, sorry. Then I've got the wrong case file. What is your MAT number, sir?
This is my lord, MAT number. MAT number to follow. Mine is blank. So, my lord, I will not be able to take your Lordship. Yeah, 1417. 1417 of 2014. 24, sorry.
This is 591. 591 is not here. I think it must be this bundle. You type this in.
Yes, my lord, it's a 2-page order. I place this order and then, my lord, I shall make my submissions on this.
Yes.
Well, the order is next to the grounds of appeal, memorandum of appeal.
Yes, sir, we have got it.
Yes. Lordship will carry affidavit service file. Then paragraph 2. The petitioner is successful purchaser in auction conducted by the bank in SARFAESI Act 2002. Until issuance of self-certificate issued on so-and-so 2021, he was never notified of any pending proceedings by the borrower against the bank under section 17 of the Act. It appears that the petitioner has suppressed material facts. I pause here for a moment. I shall make my submissions on this. What is clear is that the petitioner had due notice of the proceeding before DRT on the year 2021, albeit belatedly. The petitioner could easily have approached the DRT concerned under SARFAESI Act for seeking remedies inter alia against the bank, but he has not chosen to do so. The present writ petition has been moved after a period of 3 years of notice of proceedings before the DRT. This court is of the view that the writ petition is grossly in abuse of the process of law, apart from the fact that there is absolute no urgency whatsoever for the matter being taken out of turn. The writ petition is dismissed with the cost of rupees 5,000. Well, I do not know. I feel that the learned judge was annoyed for some reason or the other. Otherwise, this order could not have been passed on my application. My writ petition, well,
we'll keep that aside. We can remove the cost also, there's no problem. The challenge was to an order under 14.1.
Yeah.
The question is whether the petitioner, who's a successful purchaser, auction purchaser, could have moved the debt recovery tribunal against the order passed under 14.1 by the DM.
Lordship. My lord,
So,
may I make my submissions on this? My lord.
No, before that, sorry for interruption. What is the present position, sir? This order came.
No, section 14 application is pending before the DM. Kindly, my lord, take section 14 once. Well, this is a very simple matter. I don't know, my lord, why it has been made so complicated.
You want a disposal of the application.
I want a disposal of the application at my lord, for early hearing. Your lordship kindly sees section 14.
Why the government is not doing? Why the DM is sitting tight?
I do not know. Well, I tell you, lordship, this is a third application.
We will direct them.
It is not my application. Well, kindly give me 1 second.
Yes.
Bank has made application. First application 2017. That was disposed of 5 years later in 2020. Then one second application the bank made. It's not my application. Bank is making application to give me possession of a property which I purchased at a price of rupees 1 crore.
We will direct the DM to pass an order within 3 weeks.
My lord, may I submit this? Your lordship can dispose of the appeal and the writ petition. Kindly see the prayer, my prayer in the writ petition.
Yes.
Kindly come to page 80 of the
84.
Yes. Kindly, my lord, see.
Page 84.
Very simple prayer I am making, but my lord, I don't know why.
No. Why, Ms. Chaudhary? You should have taken steps. Bank should have taken steps to move.
We have taken steps, Your Lordship. Firstly, when the first section 14 was filed, that has been rejected by the DM on account of some clarification. That clarification was immediately given by the bank, but in spite of that, they have rejected. Well, then again, we have filed another section 14 application, which is pending.
We will. Where is the DM? Which respondent is the DM? What is his rank?
Well, that respondent number 2.
Respondent 2.
Which district? Howrah. Very good.
And see my prayer at page 84. That's all that I'm asking for. The appeal application, everything can be disposed of on one order. On the basis.
In fact, Learned Senior Counsel, for your information, this DM Howrah, she's a very efficient lady.
Yeah, must be so. I
tell you.
I shall accept it, man. I am sure, my lord. Otherwise, she wouldn't have been a DM of a district like Howrah. That's a very important district and very difficult district.
In West Bengal, 8 districts, all 8 DMs are from my parent state.
My lord.
Including the former DM of South Chowpis Pargana, North 24, Kalimpong, Nadia, Murshidabad. I happen to meet all of them.
So your lordship knows. I am sure, my lord, if you one word from your lordship, my lord, the matter will be disposed of. Yes. We will not come and bother your lordship.
Very innocuous prayer, Your Lordship.
Yes. this intra-court appeal is by the unsuccessful writ petitioner, wherein the appellant sought for a direction upon the district magistrate to dispose of the application filed by the respondent bank, namely the Punjab National Bank, under section 14 within bracket 1 of the SARFAESI Act 2002, dated 11th August 2023. The learned single bench has dismissed the writ petition with cost. In our considered view, the appellant could not have been saddled with cost, as the appellant being an auction purchaser and the application filed under section 14 within bracket 1 of the SARFAESI Act by the respondent bank having not been disposed of by the district magistrate, the appellant being aggrieved as they have paid the entire purchase price, had moved the court. Therefore, the bona fides of the appellant cannot be questioned, and we are of the view that this is not a case where cost should be imposed. Accordingly, the appeal is allowed. The order passed in the writ petition is set aside. As pointed out earlier, the writ petition was for an innocuous prayer at the instance of an auction purchaser in a e-auction conducted by the Punjab National Bank in respect of the property in question. Having been declared as the successful purchaser in the auction, the appellant has not been handed over possession of the property by the respondent bank. It appears the respondent bank had filed an application under section 14, which was rejected / disposed of with certain on account of certain clarifications which were required. The learned advocate appearing for the respondent bank submitted that thereafter the second application has been filed on 11th August 2023, which is
third. It is third.
Well, these are third application, second application again.
Second, the clarification was given again, it was rejected. Another fresh application was filed.
Second application was filed, in which it is stated that the required clarification was given, but the same was also rejected by the learned district magistrate. It is thereafter the third application has been filed on 11th August 2023, which is still pending before the learned district magistrate. In the light of the above, without going into the merits of the matter, we direct the learned district magistrate of the Howrah district, the second respondent herein, to dispose of the said application dated 11th August 2023 after notice to the writ petitioner / auction purchaser, the third respondent bank, namely the Punjab National Bank, and the borrower who had mortgaged the said asset with the respondent bank, who is the seventh respondent in this appeal / writ petition. Since, sir, whether the DM has been served, affidavit of service filed?
Yes, sir.
We have filed.
Though the district magistrate, though these respondents 1 and 2 have been served and affidavit of service has been filed, none appears for, there is no government counsel representing the respondents 1 and 2. However, considering the fact that the matter is being directed to be disposed of by the district magistrate, we deem it appropriate to dispose of the writ petition and the appeal with the following direction. The learned district magistrate is directed to dispose of the application dated so and so.
Well, this is one prayer I shall make. Kindly come to page 306. In order to strengthen the hand of the bank in the application, we have the purchaser has made an application which has been taken on record by the district magistrate, page 306. Let her consider also this application.
What is the date?
Well, the date is, I shall give you, Your Lordship, the date the date is, my Lord, the 28 December 2023.
Page 304.
At page 304, Your Lordship will get the date.
Forwarding that.
28 December 2023.
28
December.
December.
That date will, your lordship will get at page 304, and the application, or rather in the form of an affidavit, it is at page 306. My lord, kindly let her consider also my application. This is, my lord, just to buttress, my lord,
Yes,
the
yes.
submissions made by the bank.
Consider the application filed by the respondent bank under section 14 of the SARFAESI Act dated so and so, as also the application filed by the appellant on 28th December 2023, which was presented in the office of the district magistrate Howrah on the same date, as could be seen from the date C. After issuance of notice to all the parties concerned, the district magistrate shall consider and pass appropriate orders on merits and in accordance with law as expeditiously as possible, preferably within a period of 4 weeks from the date on which the server copy of this order is presented in the office of the district magistrate. In order to effectuate the compliance of this direction, the appellant is directed to appear in person before the appellant. The authorized representative of the appellant is directed to appear in person in the office of the district magistrate and submit the copies of the application filed by the bank, the copy of the application filed by them, as well as a copy of this order to enable compliance of the above direction.
Very grateful to your lordship.
Grateful to your lordship.
Very grateful to you. And your lordship can dispose of the writ petition and the appeal together. This order will dispose of both.
Both.
Your lordship. Very
Grateful
grateful
to your
to your
lordship.
Item number 9.
This is my
Poor person want to repair his tile shed.
Yes, my lord. Only I am praying.
Appearing for the state
well, I say
respondent, lordship, state
fact,
respondent.
small, my lord, very small fact. But I am the co-owner of a property and with the father of the private respondents. We have partitioned about 33 years ago, my lord. We have two holdings. My separate holding, he has a separate holding. Now I want to repair my the page 11, my lord. This I'm a poor man. I'm living. This is a tile shed roof. Now they prevented me. I've come to police. Police don't say anything. Now they have come to say.
Police can decide, sir. Then
No, I know. No,
we have to lock all the civil courts.
No, Mala, only one thing, Mala. I am just repairing my property. I am preparing on 30 per number of times. They are not objection. But I made any construction, my lord.
Now if they are objecting,
house is fallen, my lord.
Correct.
In the meantime, my lord.
And who's the co-owner? Your brother, is it? Who's the co-owner?
Lordship, I am appearing for the restaurant number 4, 5, and 6.
But only I am repairing.
They are encroaching my land.
But that's it.
In the name of the construction, reconstruction.
Police had given any report of the
Police will not give a report.
No, only
sir,
one.
Sir, please, one second. Sir, can he at least repair the tile roof alone? He will not encroach. Only the tile roof. Because
yes, only I'm trying to.
Wait, sir. Please wait, sir.
I'm sorry, man. I'm sorry.
In the photograph, at page number
11
and 12,
yes,
he has given photographs where the tile roof, especially page 12, the second photograph, it has fallen down. Yes. Can your client agree for that or no?
Only I am now.
I am talking to your friend, sir.
Yes. I admit, madam. Yes. I just want to repair.
I have no objection if he repair his own tile set or anything. He did not encroach my land.
I never mind. I never.
The petitioner sought for a direction upon the respondent police to take action against the respondents 4, 5, and 6, who are the co-owners of the property, as they were objecting to the petitioners/appellants repairing his broken tile roof. The learned single bench dismissed the writ petition, and rightly so, since the police authorities cannot interfere in a civil dispute. Therefore, the order passed by the learned single bench cannot be interfered. Having come to such a conclusion, we queried the learned advocate appearing for the private respondents 4, 5, 4, 5, and 6. 4, 5, and 6 as to whether his clients would have any objection if the appellant repaired the tile roof alone.
Yes.
The learned advocate on instruction would submit that the respondents are only concerned about the encroachment which the appellant is attempting to make. And if he wants to repair his broken down tile roof, it will be well open to him to do in accordance with law. Accordingly, we direct the appellant to file an undertaking before the third respondent police, stating that the appellant seeks to repair only the broken tile roof, and that he will not encroach into any land which is stated to which is being objected to by the respondents 4, 5, and 6. On giving such a written undertaking, this third respondent shall issue notice to the respondents 4, 5, and 6, hear their version, and thereafter proceed to take action in accordance with law.
And not to make any new construction, Your Lordship.
No, I don't.
It goes without saying.
No cost. I'm grateful, my lord.
That the appellant cannot make any new construction except for removing repairing the broken tile roof. And the appellant should give such an undertaking before the third respondent police. Next.
Item number 10.
Yes, sir.
Lordship, this is a petitioner in person.
Very good.
Lordship, this is a case wherein I was arrested without a 41A. That is the challenge. I've challenged that in the MAT order. But before that, Lordship, I would just like to give a brief background. Can you please come to page number 45 of Can 1?
Yes.
Lordship, me and the lady who has made the complaint, 2 FIRs, we met in Shadi.com 2.5 years back. The issue in the first FIR or the complaint in the first FIR was that I have not informed the lady that I was my divorce was pending that point in time, and she lodged an FIR under section 509 and 506 of the IPC. And I was arrested while complying a 41A notice. Lordship, I challenged that in a writ petition after the bail when I got, and then Justice Mantha ordered a district magistrate investigation against the investigating officer and the magistrate concerned because of the alimony in the case diary. Lordship, the district magistrate tabled a report. If you can see the first line, that the district judge Howrah has filed a report. It was found out that categorically the lady has lied and has given no information. The girl has a police background. That was the first point of the report. And the IO and the magistrate were sent for departmental proceedings. That was the first issue. Second issue, Lordship, if you come to the next page number 46, point number 6 to 8, my LTI in the Vakalatnama was also forced, and it is also mentioned. And it was sent for a forensic test in the FSL, which was found to be negative. Now, this case was disposed of by Justice Mantha in the month of July. Subsequently, the lady lost one more FIR. Now, kindly come to page number 54, which I have challenged the order. Under section 509, 506, 387, 354A, 354C, and 354D of the IPC. Lordship, here I was arrested without servicing a notice under section 41A. All sections are within 7 years, in violation of Pandit Kumar guideline and Satyendra Kumar until versus CBI. So I challenged it. Justice Amrita Sinha passed the order stating that this is on page number 54, Lordship, I'm sorry. On a complaint which was lodged before on the third paragraph, on a complaint which was lodged before the police in the month of November 2023, the court fails to understand the grave urgency and pressing the arrest the petitioner without servicing a notice under section 41A. The act is not in line with the guideline laid down by the Honorable Supreme Court in the matter of Anish Kumar. Lordship, firstly, in the Anish Kumar guideline and the Satyendra Kumar until versus CBI, categorically 2 issues are mentioned. If the punishment is less than 7 years, then the police will issue a notice under section 41A. That's the first.
The learned judge has said, though the learned judge in page 54, they observed that the investigation officer ought to have been a bit more reasonable and given some more time and opportunity to the petitioner to respond. However, it appears that the investigation of the subject case is over. The charge sheet has already been filed, open to the petitioner to approach the court in session of the matter for further relief. At this stage, what to do?
Yes, Lordship. The first point is, Lordship, the challenge is this 41A is not serviced and arrested. Lordship, the Supreme Court has categorically mentioned proceedings for the investigating officer.
But at this stage, sir, Mr. Roy.
I'm coming to it, Lordship. I'm coming to it. It is not only the 41A. There are one more point, Lordship. When the bail petition was moved, Lordship, this case has 2 points. One, it wasn't alleged that I have sent letters. The lady works in a bank. that I have sent letters to Indian Speed Post making defamatory comments about the lady to her colleagues and in her neighborhood. That was the first thing. So, Lordship, when the bail was moved, it was said that they have evidences that I have sent those letters. So, it would be in the case diary. That's the first thing. Secondly, Lordship, they have also mentioned that I have sent SMSs demanding extortion of 15 lakh. That is also mentioned in the FIR, section 387 of the IPC. So, those two things, Lordship, I have received a charge sheet. Neither those SMSs which reflect a 15 lakh demand, and before the arrest, that they have said that they have evidences that I have sent those letters. So that CCTV footage would be there. So can they show the CCTV footage in the case diary? So they made the submission. If you may please come to the bail application, just allow me a minute. Page number 60, Lordship. Page number 60, paragraph 4. The learned PP raises objection by submitting that IO is present before the court with the CD, and the accused petitioner has sent obscene text, WhatsApp messages with photos to the complainant through speed post and threatened the complainant in different ways. So like the last FIR, Lordship, so I'm sure the SMSs which were sent to the lady, which has 15 lakhs extortion demand, and the it was sent from the post office as per the IO. So they would have this in the case diary. But when I research it, there is no SMS that it reflects 15 lakhs were demanded. And I do not see any kind of photo or prima facie. After the arrest, Lordship, dated 12th of February 2024, there was a sample handwriting taken by the IO in front of the Railway Magistrate Court in Howrah. So I am not sure what is the status of the report, but I would pray to the court for the 41A issue, because if you arrest without a 41A, there is a...
Sorry for interruption, Mr. Roy. Please. Please come to page 32. That's the prayer in the writ petition. Slowly. Page 32. Mandamus commanding the respondent so-and-so, specifically Superintendent of Police Lal Bazar, officer in charge Shampukur Police Station, to make appropriate investigation on the basis of the complaint by the petitioner and to render police protection for protection of the life of the petitioner. That was the prayer. Now you are arguing the matter which ought to be argued before the trial court, where the matter's charge sheet has already been laid. We don't want to...
In page 29 and 30, I have mentioned. In page 28, 29 and 30, Lordship, I have mentioned the 41 issue.
The manner in which we can deal with the matter. The prayer sought for is to appropriate investigation. Investigation is complete. Charge sheet has been laid. You can approach the concerned court, file an application for re-investigation, fresh investigation, or transfer of investigation. All remedies are open.
But Lordship, I have a specific point here. Like the last case. Here, Lordship, in both the cases, the first and the second.
That is not your prayer, sir. Please.
But Lordship, I made this prayer. I made this prayer over in page 28. The allegation made in FIR 243/23 that they have emails and sent demanding page number 30, extortion of 15 lakhs sent to the petitioner and responded, recorded under the evidence.
That is on the merits of the matter, Mr. Roy. Sorry.
So I mentioned this, that they have demanded, but I do not see that.
We are not undermining the merits of your case.
Right.
But we are only before, you are saying that you are before the wrong forum for that. In that, this can't be gone into in a 226 petition. If there is threat to life, you give an application, the concerned police will examine as to whether your threat perception is there, give you police protection at your cost. If there is
I understand the second part, Lordship, the reinvestigation issue. I completely agree that this is not may not be the right forum. I would definitely take, but the first issue, Lordship, whether the charge sheet is completed or non, Lordship, if the Supreme Court guideline says 41, Lordship, I can only approach the court. I can only approach the court after the bail. I cannot approach the court before the bail. So I approach the court after the bail, and it was filed in April.
That point is available with you. That point is available. You say right from the inception, everything is wrong. Like 41A notice is there, therefore arrest was wrong, etc., etc. Everything you can plead.
But Lordship, reinvestigation would not help. I want the departmental action, because if this happens second time, it's the first time, Lordship. 41A, if you do not issue a 41A, arrest somebody, Lordship, it's a violation of the Supreme Court guideline. If the IO is let off this way, Lordship, first time they did the same thing. Again, they're doing the same thing. It can happen. I completely agree in the second part that the issue with the charge sheet which I received, that the SMS do not reflect, or the prima facie photograph of the CCTV footage is not there. I may go in for reinvestigation, but I don't think it will suffice. I will go for a quashing then. But the first part, Lordship, 41A, how can the High Court leave the IO without any kind of proceeding, Lordship?
Okay. We have heard Mr. So-and-so, learned appellant appearing in person. The appellant was was the writ petitioner in WPA 10269 of 2024. The main prayer sought for in the writ petition was to issue a writ of mandamus to the respondent authorities, specifically to the Superintendent of Police Lal Bazar and the officer in charge Shampukur Police Station, to take appropriate steps according to law and make appropriate investigation on the basis of the complaint made by the appellant writ petitioner, and to render police protection for protection of life of the petitioner / appellant. Prayer D is to quash and set aside FIR number 243 of 2023. The other prayers are interim in nature. The learned single bench examined the contentions advanced by the appellant who appeared in person and pointed out that the investigating officer ought to have acted a bit more reasonably and given some more time and opportunity to the writ petitioner / appellant to respond to the notice under section 41 capital A of CRPC. The learned single bench noted that the investigation is in the subject case was completed and charge sheet has been laid, and accordingly left it open to the appellant petitioner to approach the learned court in session of the matter for any further relief that he seeks. Before us, the petitioner appearing in person would reiterate the submissions made before the learned writ court and also refer to certain averments made in the writ petition. Be that as it may, the petitioner had sought for appropriate direction, appropriate investigation on the basis of his complaint, and for police protection. The investigation has been completed and charge sheet has been laid. If, according to the petitioner, appellant, the investigation was not proper, then the appellant has got sufficient remedies under the relevant statute. The prayer for quashing the FIR cannot be entertained, that too in a petition filed under 226 of the Constitution of India. Therefore, we dispose of this appeal, leaving it open to the appellant to raise all issues, including the issues canvassed in the writ petition, before the learned court, before which the charge sheet has been laid. All points are left open.
Lordship, a point.
I am grateful to Lordship.
Lordship, a point.
But I was appearing on behalf of the state.
Yes,
Lordship, 41A, where shall I go, Lordship, for the 41A issue?
You'll have to ask your advocate friend.
That's Lordship. I'm a lawyer. So 41 is something have to go to the High Court and Supreme Court, Lordship. Then it's a SLP the next time.
Yes,
I cannot
sir.
approach anybody for the 41A.
You please take some legal advice.
Lordship, I'm not asking for the second, for the first time. 41A has to be done through the SLP or High Court and then SLP. There is no other option available for me.
Yes, sir. Yes, sir. We have heard you, sir. Thank you, sir. Next.
Item number 11.
My lord, in 11, my lord, I have not yet filed the CAN application.
I'm appearing on behalf of the my lord, private respondent, my lord.
Did you
The
lodge
my lord, encroachment, my lord, public land, my lord. After filing my lord, appeal, my lord, they have only later and stopped the my lord, by demolition of construction, my lord, unauthorized occupy the private public land, my lord. In front of this respondent number 11.
My lord,
Under the
then 1 or 2 weeks time, I will file the application and
my lord, on the basis of this, my lord, filing, my lord, they have wrote a letter, and on the basis of the letter, my lord, the stay
appearing for whom?
on behalf of the my lord, private my land, my lord, informed by my lord, enjoy the public land, and the my lord, engage and engage, my lord, stop, my lord.
No, this is absent. Kun case ta apne aaj se?
11.
My lord, he is making my lord misleading statement. I am on my royalty land. I will, my lord, by way of CAN application.
You are the writ petitioner. Your writ petition was dismissed.
Yes.
What was the prayer in the
My
writ
lord,
petition?
my prayer is that I am a royalty land for last 50 years. I am running the, my lord, shop from my fathers. Now somebody purchased some portion of the land and they are alleging that I am an encroacher. But there has been no proper demarcation and no measurement. So that's why, my lord, I have preferred this appeal that we shall request the local BLRO that proper investigation should be made about the measurement should be done. Thereafter, my royalty land should be spared, and if there is any alleged encroachment, that should be removed. That is our prayer.
Sir, actually You filed an appeal before the district magistrate Murshidabad,
Yeah,
which was also disposed of.
that is
After
that is
giving,
that
you
was wrong.
challenged that order, sir.
My lord, against that order, my writ petition was filed, but my lord, the learned man trial court was pleased to hold that I made some admissions that is not correct, and there was no inquiry, no notice was given to us. I am the one. I have annexed the deed, title deed.
No. The learned judge has recorded that you have admitted
So
the.
that is not correct. I never admitted. I did never admit. That is my wrong recording. That's why, my lord, I am.
How can anybody become owner of a public works department?
No, not at all, my lord. Some portion I have, my lord, that by way of application, I shall bring it to the.
All right, learned advocate for the appellant prays for 3 weeks' time to file the stay application.
Yes.
Along with annexures, leave granted. So the pendency of this appeal will not be a bar for the authorities to proceed in furtherance to the order passed by the district magistrate. Next.
And my lord, after making proper measurement, because my lord, some persons purchase some portion of the land. Now they are alleging that I am the encroacher. Government has not made me allege that I am the encroacher.
Sir, they made a complaint. The BLLRO conducted an inquiry.
That complaint was motivated complaint. I am for last 50 years.
Thereafter, the BLLRO has inquired into the matter and found you to be encroacher. You filed appeal before the DA.
Without any notice, without any information, order was passed.
BLR, my lord, notice, my lord, investigation, inquiry was made, my lord.
He is, my lord, without understanding the issue, my lord, he is making
All
false.
right, next.
Item number 12.
I am grateful, my lord.
Well, item number 12, I am for the appellant, Lordship.
What happened?
My lord.
Lordship, this is.
I am appearing on behalf of the respondent number 12 and the rate petitioner.
First, you have to convince your brothers and sisters. They are not making no objection.
Lordship, this is regarding a dispute in connection with one shop room, Lordship.
What to do, sir? First, now what has happened is your common enemy is the Zilla Parishad.
Lordship?
Your common enemy is the Zilla Parishad. Because father passed away and you wanted the shop room to be transferred in your name, they asked for no objection certificate from all the legal heirs. So you will have to either get an NOC or they will not transfer the allotment. So better plead with your siblings, mother, get NOC and give due share of profit to them also. Then they will grant.
And Lordship, my only humble prayer, Lordship, till disposal of the appeal, Lordship, let there be an adjunctive order of status quo, Lordship. Because, Lordship, I have annexed one sketch map, Lordship. I am the appellant, Lordship. I have annexed one sketch map, Lordship, for your Lordship's better.
One thing, sir. Where is the lease deed or license granted to your father?
Lordship?
The shop room was given to your father.
Lordship.
Allotted. Where is the letter of allotment? Please show. It is not transferable, sir. That's the problem.
Lordship.
If it is a lease.
Lordship, in view of such Lordship, may I humbly submit, Lordship, in view of a compromising agreement, Lordship, between two brothers and father, Lordship, annexed that agreement I have annexed, Lordship, in the year 2004. I have been continuing business, Lordship.
You show the original allotment order in the name of the father.
Allotment letter, Lordship, right?
Who appears for the Zilla Parishad?
Zilla Parishad.
Zilla Parishad, my lord.
Purva regulated market committee. Market committee.
Yes.
And I am appearing.
All right. Did you issue a license or a lease?
Well, no license. It is a toll. Collection of room has been allotted and further toll that has been collected. It was in the name of Mongol Shah. He has the original allotee. Now the allotee expired. Now the two sons are fighting each other. I am entitled. Who is claiming I am also entitled.
You have to. You conduct public auction.
So we are agreeable. Who can? No objection taken from other legal heirs, we can give him. Repeatedly, we have asked them.
In presence of said Mongol Shah, Lordship, two brothers in presence of Mongolsa and two brothers, Lordship, an agreement has been executed, Lordship.
No, no, there is
In
a
the
no
year
validity.
2004,
There is a
I
no
have annexed the
validity.
agreement, Lordship. Kindly see, Lordship.
There is no validity of that agreement, my lord. At that particular time, the
How
original.
can there be no validity, Lordship? I asked this to myself, Lordship.
No, we are asking a question to you. How this agreement is binding on the market committee?
Yes.
It doesn't bind, sir. Sir, elementary principle of law, you will have to take note of that. To your father and two brothers enter into some agreement, and after the demise of the father, you want that to be executed against the market committee. How it can happen? This writ petition, the appeal is directed
Lordship, just
against.
one humble submission, Lordship.
No,
In
no,
page
no, no.
90, Lordship, just one indulgence, Lordship, praying for Lordship. Page 91, Lordship, since page 91, Lordship, I've been continuing paying the rent, Lordship. Kindly see, Lordship.
Behalf of Mongol Shah,
Lordship,
the
on behalf of Mongol
deceased father, not on his behalf.
But payment has been made by me, not by my brother, the writ petitioner, Lordship.
But on
Sir,
the
it
name
is
of
in his name, sir. What are your... We will dismiss it with cost. This intra-court appeal by the unsuccessful writ petitioner is directed against the order dated 16/7/2024 in WPA 8988 of 2023. The appellant's father was allotted a shop room by way of collection of toll by the regulated market committee. The appellant's father expired, and the appellant now insists that the allotment should be transferred in his individual name. The market committee, though would have been justified in resorting to public auction, agreed to the request subject to production of no objection certificates from the legal heirs of the appellant's father, namely his brother, mother, and sisters. The no objection certificate has not been produced since the other siblings have not agreed to the said request. With this grievance, the appellant filed the writ petition. The learned writ court rightly dismissed the writ petition. The appellant places reliance on an agreement entered into between himself, his brother, and father. This agreement is not binding on the regulated market authority. The learned advocate for the appellant would contend that till date the appellant is paying the amount payable to the market committee and relied upon a receipt dated 31/7/2024. As is evident from the said receipt, it is in the name of Mangal Saha, who is the appellant's father. Therefore, based on such receipt, the appellant cannot claim any individual right over the concerned shop room. Therefore, the appellant has not made out any grounds to interfere with the impugned order. Appeal fails, dismissed. Next. Next.
Item number 13.
May I file my affidavit of service, Lordship?
Affidavit of service taken on record. Item 13.
13, my lord, I am appearing for the petitioner, my lord. I am playing for not this week, my lord.
Why? No. You tell us what it is, small matter. Unauthorized illegal construction subject piece of land at the behest of private respondent 10 and 11. Several representations. Last of representation. Learned additional government submit subject land is measuring about more than 1 acre on which illegal construction alleged to he submits that the decision shall be taken by the jurisdiction authority, namely so-and-so of Zilla Parishad, and not the Pradhan. Above the subserved justice, the petitioner liberty to submit fresh representation. Submitted concerns so-and-so shall take necessary. Thereafter, so-and-so within a period of 3 weeks. On the basis of the finding, the so-and-so granting them opportunity every 4 weeks. Wonderful order, sir. If the matter had come before us, we would have dismissed it. This intra-court appeal is directed by the appellant, by the writ petitioner is directed against order dated 26/2024 in WPA 15072 of 2024. The appellant writ petitioner alleged that the respondents 10 and 11 have encroached a piece of land and put up unauthorized illegal construction. The learned writ court, after elaborately considering all issues, had directed the representation to be made by the appellant to be considered and also issued consequential directions. We find no grounds to interfere with this order. Dismissed. Next.
Item number 14.
14, your lordship, I am for the appellant. Service has not been completed. I am praying for 1 week time, your lordship. Because there are so many private respondents. If your lordship kindly fixed next week.
One second.
Suit is pending, sir. There is an order of status quo also.
Yes, my lord, but service has not been completed. Kindly give
That is
me
different. That is not a ground to take an adjournment when the court wants you to make a submission on merits. What is wrong with this order? Your client, a 78-year-old man, could not enter the property. He has filed a suit. He has obtained an order of status quo. If there is a violation of the order,
status quo order is there, but the appellant before your lordship continuously the private respondent give threat to the appellant, and he is unable to enter his own property, your lordship. For this reason, he went to the police to protect him for entered the property.
No, that can't be done, no? When there is an order of status quo. A status quo means what? Whatever was there, as is, where is condition.
Yes, my
On
lord.
the date of the order, as is, where is. On the date of the order, your client was not inside the property. He is not in possession of the property. So therefore, the question of interpreting the order, you file another interlocutory application in the suit seeking permission or direction upon the concerned OC to give police escort or assistance.
I am led by Mr. Devbrata Sara. Kindly give me the 1 day time, your lordship, regarding this. Kindly give.
At the request of the appellant, adjourn.
Grateful, my lord.
Now, which matter we are going to take up? Either item 15. One matter, Mr. Datta, Friday we were hearing one income tax matter.
My lord.
Mr. Om Narayan Rai was to reply.
Okay.
My lord, I am appearing in the matter, my lord, for the appellant.
Yes. We have heard
Please,
Mr.
lordships.
We have heard Mr.
Indeed, my lord. My learned senior, my lord, Mr. Khaitan, I am being led by my learned senior, and he is appearing virtually.
Yes. I am also virtual. He is also virtual.
Lord, my learned senior would make a 2-minute submission, my lord, before Mr. Rai starts the submissions, my lord.
Yes.
May I just take 2 minutes of my lord's time, lord?
Yes. Sir, once again, we'll just get the case file.
Lordship.
Original side, right now.
Now, original side matter.
Yes. Yes, sir.
Well, it's I had drawn it. My lord had gone through the questions which were formulated in the petition. But question number 4 was to the effect that both the assessing officer as well as the commissioner appeal had found that purchases had happened, whereas the tribunal has sought to hold that there are no purchases at all. No, that was the 4th question. Now, the assessing officer's order is quite clear. He says that the purchases have happened outside the books. That's what he says. Because the records were given to show consumption and sale, etc. Now the commissioner appeal has also given that finding. Since his order is very long, that particular sentence, if I may draw attention to, that's the only thing I wanted to draw attention to, page 75
of volume 1.
Yes, no. It's page 75, the new paragraph, bottom half of the page. But the 6th line that I had actually placed, and the next sentence I ought to have read, which I missed out. My lords, I found it.
The entire purchase transaction, meanwhile, took place out of the books.
Yes, so therefore, he says that there were purchases. Therefore, both the concurrent findings are of the assessing officer and the commissioner appeal that the purchases have happened. The other thing, it was what fell from my lord's when looking at page 76 and 77 was that he's talking about circular transactions. Actually, what he is saying there is that yes, the alternate plea of the assessee is that the goods have been purchased. So therefore, the purchase cannot be ignored. But then he says that the assessee should have then come forward from where he got the money for making those purchases and given an account as to how the purchases were made. And since he has not owned up to that, therefore, the alternate argument of the assessee is also not acceptable. This is so. It is not that he's talking about a circular transaction here. He's talking. He's really saying that assessee should have given a full account of the purchases which have happened outside the books. And in the absence of that, he says, I will not consider that at all. Now the just last aspect, the 6th question, that page in the which was there, regarding not granting benefit of brought forward unabsorbed depreciation in business loss. Now the reason why it was not allowed was that they invoked section 69C. Now, of course, my submission has been that 69C has no application. In fact, the entire group of sections from 68 to 69D do not apply here. Now, the one sentence is invoked. Section 115 BVE comes into play. That section relates taxation at the 60% without allowing any set of this section 69 BB benefit of denied and tax is imposed on the entire which is so this is question number.
Lord, I believe there's some network issue, my lord, that my learned senior is facing.
Yes, wait.
Yes, he's joined back, my lord.
You please unmute, sir.
So that is all that I wanted to say, Lord. I just didn't want to take any more time.
Yes, Mr. Rai.
Wait, please, Your Lordship. My lord, Your Lordships have been taken with the facts, my lord, to the facts, my lord, in some detail. My lord, before taking Your Lordship, my lord, to the relevant facts, my lord, of the case, Lord, just to show to Your Lordship the other side, Lord, I would, my lord, beseech Your Lordship to kindly have a look at the law on the subject, my lord, because one of the submissions made by my learned senior friend is that the scope, my lord, and the standard of inquiry.
1 second, I'll just take the Income Tax Act. Yes. Slow. Yes, sir.
Yes, my lord. My lord, my submission is, my lord,
Hmm.
that it has been held, my lord, by high authorities
Hmm.
that, my lord, the scope and standard of inquiry, my lord, in a matter to which, my lord, any of the sections, my lord, starting from section 68, my lord, and ending in section 69D,
Hmm.
my lord, are applicable or is applicable.
Hmm. Yes, 16.
My lord, starting from section 69 and, my lord, till section 69D, all of these sections, my lord, are based upon the same legal principle and they embody the same rule of evidence. This has been laid down, my lord, by the Honorable Delhi High Court as far back as, my lord, 1980, and that, my lord, holds good even today. Before, my lord, taking your lordship to the facts of this case, may I place that judgment once, my lord? I have emailed the judgment to your lordship's registry, my lord.
Hmm.
My lord, it is Yaduhari Dalmia's case.
What is the citation, sir?
My lord, it is 1980 126 ITR 48. My lord, I am handing up, my lord, a copy, my lord, of the SCC online Delhi, my lord, which, my lord, is equivalent to the 126 ITR, my lord, on the
What is SCC online citation?
SCC online citation Delhi, my lord, 1980 SCC online Delhi 370. My lord, this SCC online citation, my lord, is no longer available on the SCC, my lord, if ITR is, my lord, subscribed to.
Mm-hmm.
Lord.
All right. You please read the relevant paragraph.
Yes, my lord, it's up, my lord, on the
Let them share the soft copy.
The first judgment. Yes. My lord, this is the ITR. My lord, it will match with paragraph 13, my lord, of the SCC citation. My lord, kindly take, my lord, page 9. PDF page 9. And page 56. Arunicha. 9. Correct. Bus. No, my lord, yes. The last sentence, my lord, the last paragraph at the page, my lord, which is up, my lord, on the screen. Last paragraph, my lord, it begins with, we shall consider.
Yes.
We shall consider the question posed before us in two parts. The first is whether in a case where there is direct and clear evidence to show that an assessee has incurred some expenditure on an item which he has not recorded in his books at all, or which exceeds the amount recorded in his books, and he does not offer an explanation regarding the sources from which the expenditure was incurred, or the explanation offered by him is unsatisfactory, it is open to the ITO to treat the amount of expenditure or the unexplained part of it as having been met out of the assessee's income from undisclosed sources of the relevant accounting year. The second question will be whether on the facts and in the circumstances of this case there was material before the tribunal to come to the conclusion that there was expenditure incurred by the assessee on his marriage, which has not been satisfactorily accounted for. Now, my lord, paragraph 14, that is the next paragraph, my lord, is important. My lord, it begins with so far. Yes, lord, so far. So far as the first question is concerned, we think that the answer should be in the affirmative. It is no doubt true that section 69C, which makes specific provision for this situation, was inserted in the IT Act only with effect from April 1, 1976 by the Taxation Laws Amendment Act 1975. But we are of the opinion that the statutory provision was merely clarificatory and embodies a rule of evidence, which is even otherwise quite clear. In the first place, we may point out that section 69B was in operation even during the assessment year 1970-71. This section makes provision for a case where the assessee is found to have purchased or acquired an investment. My lords, I'm not getting it.
Yes.
Bullion, jewelry, or other valuable articles, and the ITO finds that the amount expended on such acquisition exceeds the amount recorded in the books of account maintained by the assessee, and the assessee offers no explanation about such excess, or the explanation offered by him is not, in the opinion of the ITO, satisfactory, the excess amount may be deemed to be the income of the assessee for such financial year. The principle behind this section is equally valid, where the expenditure incurred by the assessee is not for the purpose of acquiring bullion, jewelry, or other valuable article, but for some other purposes. It is well known that the whole catena of sections, starting from section 68, have been introduced into the taxing enactments step by step in order to plug loopholes and in order to place certain situations beyond doubt, even though there were judicial decisions covering some of the aspects. For example, even long prior to the introduction of section 68 in the statute book, courts had held that where any amounts were found credited in the books of the assessee in the previous year, and the assessee offered no explanation about the nature and source thereof, or the explanation offered was, in the opinion of the ITO, not satisfactory, the sum so credited could be charged to the income tax as income of the assessee of a relevant previous year. Section 68 was inserted in the IT Act 1961 only to provide a statutory recognition to a principle which had been clearly adumbrated in judicial decisions. The provisions of sections 69 and 69A are likewise purely clarificatory in nature. It has been held under section 69A that the section embodies only a rule of evidence and that it would be applicable even in respect of assessment year prior to its insertion. On the same analogy, we think that it follows as a normal rule of presumption and evidence that where an assessee has, in fact, incurred certain expenditure and is not able to account satisfactorily for the same, an inference can be drawn that the expenditure or the unaccounted part thereof must have been met out of undisclosed income of the previous year. The case of an item of proved expenditure is in principle no different from that of a cash credit. In both the cases, the assessee is in possession of certain funds during the previous year, the source of which he is unable or unwilling to explain satisfactorily. It is a matter entirely within the assessee's knowledge as to how the cash credits came to be introduced, or the items of wealth came to be acquired, or the expenditure was incurred. And once it is postulated that such cash credit or investment or expenditure belongs to the assessee, then his failure to explain the same or to explain it satisfactorily can constitute a reasonable ground for an inference that the source thereof must be an item taxable under the Act. Otherwise, if a non-taxable source or a capital item was utilized for the purpose in question, the assessee could and would easily have come forward with an explanation to the said effect and proved it to the satisfaction of the ITO. We are therefore of the opinion that the whole history of the introduction of sections 68 to 69D and the judicial decisions bearing thereupon clearly establish the proposition that these sections are only clarificatory, and that even otherwise an addition can be made towards income from undisclosed sources in respect inter alia of amounts of expenditure which the assessee is found to have actually incurred but not satisfactorily explained. Lord, this, my Lord, sets up, my Lord, the stage for, my Lord, application of all the judgments and all the principle which, my Lord, are applied in section 68 cases. My Lord, therefore,
yes.
Therefore, my Lord, in my very respectful submission, my Lord, the Commissioner Appeals or the ITAT, my Lord, cannot be faulted for having relied on judgments, my Lord, which were, my Lord, pertaining to section 68 additions. My Lord, there is no real difference in principle. My lord, I shall be showing to your lordship, my lord, that in cases, my lord, where additions, my lord, have been made under section 69C also, my lord, it has been found by the courts that identity of the person concerned, creditworthiness, genuineness of the transactions, these, my lord, fall within the scope of a relevant inquiry.
Yes.
No, my lord. Once, my lord, we know the rules of the game. My lord, let us see how, my lord, the game has been played. Whose onus was, my lord, whose onus it was, my lord, to start? To, my lord, show. My lord, I rely on the next judgment, my lord, of your lordships. My lord, the recent one, my lord, where a catena of judgments, my lord, have been, my lord, discussed. My lord, it is for it. My lord, it is Balgopal Merchants. My lord, paragraph 17.
No, please scroll down. One second.
Yes, fourth.
No. We like to see the cost title. Citation we want.
Citation. My lord, this
First
is, my lord,
page number 1.
2024 162
2024
162 taxman.com
162 taxman.com
465
Calcutta. Balgopal Merchants. Versus PCIT. Yes, sir.
Now, my lord, kindly take, my lord, paragraph 17 at the 4th page of the PDF, page 4. Last paragraph. Paragraph 17, my lord. The law on the subject is fairly well settled. The assessee as to the burden of proof would include the proof of identity of the investor, the capacity of the investors to advance money, and the genuineness of the transaction. The assessee has to prove these three factors by producing acceptable evidence, and only then the owner shifts on the department. Therefore, my lord, this has to be proved. All three of it.
Yes.
Now, my lord, with this, my lord, setting of law in the, my lord, at the background, kindly, my lord, take the assessment order once, my lord, volume 1.
Page 24.
Yes, my lord, page 24. I shall, my lord, only take your lordship, my lord, to page 28. My lord, I shall take your lordship to the other, my lord, aspects also, my lord, but first this. But page 28. Kindly take note, paragraph 4.4. Not only, my lord, these persons were not found, no confirmation has been submitted by the SSE companies from the parties in question. Even confirmations were not there. Lord, this is the assessment order prior to the remand. Now, my lord, subsequent to the remand report, your lordship will kindly take note of a few pages, my lord, from the CIT appeals order.
But one thing, sir, if you see that the assessing officer himself admitted
Yes.
that they have filed GST returns.
Yes, they had, my lord. They had filed, my lord, and there was a large amount of difference between my lord, the sales, my lord, that was shown by them and the sales, my lord, actually registered. My lord, there also, my lord, there is a problem. My lord, if your lordship sees, my lord, page 28, the assessee has submitted details of total purchase from the sales parties at rupees 57 crore and odd. And, my lord, the 7 parties, my lord, in respect of whom the GST returns are filed, my lord, those show 45 crore and odd. As per the records available, none of these parties have digital footprint, that is email ID. Therefore, the department could not serve notice on them. Thereafter, my lord, postal service is done. That your lordship will find, my lord, at page 48.
No, the next line. From the date of purchases, it is clear that there is a large
difference in the purchase reported by the SSE as against purchases made from these parties reflected in the GST data.
So, prima facie, unless there is identity is established, Mr. X is the person who has effected the sales in favor of the SSE.
Yes.
The assessing officer says yes. X has supplied the GST data is there, but there is a gross difference.
Yes.
So, where is the question of a necessity to submit a confirmation? That's their argument. They say there were people you have purchased from somewhere, but these people could not have purchased. Probably that theory of circular transaction has been brought in by the CITA. It must have been outside the books. That's what the AO ultimately concludes. That is upon remand. No? 1 second.
That is why, my lord, the question arises as to what, if my lord, these persons, my lord, first of all, my lord, if GST data, my lord, has had to show the results of the same sales, my lord, the figure should have matched. Second, my lord, there are 7 people from whom, my lord, sales have been, my lord, my lord, have been stated to have been sale transactions have been entered into. All 7 persons will disappear at the same time. My lord, it is too much to believe. My lord, in the cases that have been cited, my lord, I shall be showing it to your lordship, my lord, the difference. My lord, it is not the case of one solitary person, my lord, having disappeared, or one person, my lord, having turned turtle to, my lord, what he said earlier. All 7 persons, in respect of which, my lord, sales with whom, my lord, sale transactions have taken place, my lord, all of them become, my lord, incommunicado. None of them, my lord, is traceable. Some, my lord, who are traceable, my lord, have something else to say.
Crane operator.
Yes, and plumber.
Plumber.
Now, my lord, kindly have a look, my lord, at page 28. I'm sorry, my lord, page 45. 48. 47 and 48 of the CIT appeals order.
Yes.
Lord, page 47. In this connection, it may brought to your kind notice that during the scrutiny assessment proceedings, a show cause notice was issued on such and such date for verification of the identity of parties from whom raw material was purchased by the SSE company, their creditworthiness and genuineness of the transactions. A list of the parties from whom raw material was purchased by the SSE company who have not filed their returns of income for financial year such and such is given below. My lord, this is the list of people. My lord, name of the party number 1 is Vasudev Malik, who is, my lord, the proprietor of Messrs. Lakshmi Trading Company. Then Ashok Kumar Gupta, Messrs. Pioneer Enterprises, Sopon Shashmol, NB Trading Company, Harish Chakram, Shri Pashupati Enterprises, Soumya Chakraborty, Sun Traders Innovation Consultancy Services, Sanjay Maiti, Shagun Traders, Swadeshi Chemicals, Mahadev Trading Company, and then Ashish Mishra, Others Trading Company. The SSE company had preferred appeal before the learned CITA Kolkata, that is before your good self. Remand report has been sought. I am, my lord, skipping that portion. My lord, last line. As directed, notice under section 131 of the Income Tax Act were sent both through ITBA module and through speed post to the following 7 parties from whom the purchases were claimed to have been made. My lord, all 7 parties named. But out of 7 parties, the above notice could be served by the postal department only to the party, namely Ashish Mishra. Remaining 6 parties to whom notice could not be served by the postal department are as follows. My lord, Buddhadev Malik, my lord, not known. Ashok Kumar Gupta, no such person. Swapon Shashmol, no such person. Harish Chakram, addressee cannot be located. Soumya Chakravarti refused the return. He was there, but he did not accept. And Sanjay Maiti, no such person in his address. Hence, identity of the above persons, creditworthiness and genuineness of the transactions made by the SSE with Messrs. APL Metals Limited could not be ascertained during the remand proceedings. Moreover, though the notice was served to Ashish Mishra by postal department, Ashish Mishra did not appear for personal hearing fixed as per the said notice under section 131 of the Act, for which the creditworthiness and genuineness of the transaction made by Ashish Mishra with the SSE company could not be ascertained. Now, my lord, this search and seizure, my lord, appraisal thing comes. It is relevant to mention here that a search and seizure was conducted on various residential and office premises of APL Group, including the SSE on 7/12/2021 and subsequent dates. Search warrant was also executed in the name of the SSE company. During the course of search and seizure operation, books of accounts and incriminating documents were seized. Accordingly, the SSEs of the group were centralized to this office under a single AO for coordinated investigation. Subsequently, the appraisal report along with seized impounded documents and other related documents were received in this office in due course. On perusal of the appraisal report, it is found that 6 out of above mentioned 7 individuals in question have made transactions with APL Metals, that is the SSE company, by way of issuing bogus bills, and creditworthiness of them are under suspicion, as they have not filed their ITRs for the relevant assessment years. My lord, ITRs also not filed. My lord, there is discrepancy, my lord, in the GST. ITRs not filed. Persons, my lord, cannot be located at the place where they should be. Analysis of the seized impounded document shows the following findings. Letters, notices of superintendent, headquarters, anti-evasion, CGST and Central Excise, Howrah Commissionerate was seized from the residential premises of Swapon Shashmol, which could not be explained by the SSE. It may be mentioned that Swapon Shashmol is one of the director of Messrs. Shashmol and Nath Engineering. Here in this case, he is the proprietor of NB Trading. During the search proceedings case of the group, a team was sent to registered address of Shashmol and Nath Engineering Private Limited, which was found non-existent. Thereafter, one search team was sent to the residential address of Shri Swapon Shashmol, who is the director of Shashmol and Nath Engineering Private Limited. During the course of search proceedings, statement of Shri Swapon Shashmol was recorded on oath under section 132(4) of the Income Tax Act, wherein he has stated that he is a plumber, earning his livelihood, and his profession, his company has not supplied any goods to any person. Relevant portion of statement of Shri Swapon Shashmol has been reproduced as under. My lord, the question is, as per MCA data, it is seen that you are additional director in Messrs. Dark Creative Media Private Limited. Also, as per the information available with the Income Tax Department, 2 proprietorship concerns, namely NB Trading Company, GST number given, SS Trading Company, GST number given, exist in your name. Please state where the books of accounts of your proprietorship concerns are kept. Please offer your comments on the issue. Sir, I do not know anything about this. I even do not know the meaning of books of account. Please state your source of income. Sir, I am a plumber by profession and I earn rupees 500 per day on an average. From the above discussions and your previous replies, it is now amply clear that your proprietorship concerns at Messrs. Shashmol and Nath Engineering Private Limited are shell entities and had no real business whatsoever. These have been formed for the sole purpose of providing accommodation entries, raising fake GST invoices, passing on bogus ITCs. Please offer your comments. Sir, I agree with the above. From the statement of Shri Swapon Shashmol, it is clear that Messrs. NB Trading is a shell entity providing bogus bills only. In the course of post-search proceedings, Shri Harish Kumar Chakram was summoned under section 131 of the Income Tax Act, requesting his personal appearance in response to the summons so issued. So Harish Kumar Chakram appeared and his statement was recorded on oath under Section 131 of the Income Tax Act. In his statement, Shri Harish Chakram has stated that he is not engaged in any business. He is merely a crane operator currently employed at L&T Limited. He has also informed that a firm, namely Shri Pashupati Enterprises, was incorporated by using his identities fraudulently, and that has been used by some person unknown for his illegal purposes. Shri Harish Kumar Chakram has admitted in his statement that the entire sales booked by Messrs. Shri Pashupati Enterprises in the name of Messrs. APL Metals Limited is completely bogus, and no goods have been supplied with such bogus bills. The relevant portion of his statement has been reproduced hereunder. From the records available with the department, that you are proprietor of Messrs. Shri Pashupati Enterprises having office address at ground floor, 4 Surya Sen Palli Shastriji Road, West Bengal, and GST number such and such. Please furnish details of business performed by the firm since its establishment. Madam, I do not have any knowledge.
We went through this. Page
Yes,
50.
Lord, your lordships have gone through it. Lord, I shall not
He
trouble the
says,
lordship.
and he has also lodged an FIR
Yes.
against this Bhavan
Yes.
Kumar Singh
Yes.
and Satish Pandey.
Now, my lord, your lordship will kindly take my lord page 60 then. 60. 60. My lord, just below the chart, during the scrutiny assessment proceedings, the AO noted that some of the parties from whom purchases had been claimed to be made by the appellant during the impugned period had not filed their returns of income for the corresponding period. Lord, this is the first ground on which, my lord, the assessee's, my lord, case is disbelieved. This is one of the grounds. Next, a further suspicious circumstance that was noticed by the AO during assessment was that even though these vending parties were claimed to have shown huge sales to the appellant, mostly amounting to sales of over 5 to 6 crore and even crossing 15 crore, going up to as much as over 20 crore, these parties showed no digital footprints anywhere. My lord, crores, my lord, exceeding, my lord, 15 crore, 5 crore, 20 crore, my lord, no email address, no digital footprint. In this day and age, when most statutory compliances under any statute are to be done online, the absence of any form of digital presence, not even an email ID, is very strange and may be considered to be a suspicious circumstance in itself, as indicating the lack of these statutory compliances. A show cause notice was accordingly, my lord. I am skipping that list of parties, raw material purchase. Thereafter, my lord, your lordship will take the last paragraph at the page. In addition to the fact that the said parties were found not to have filed their income tax returns, the AO also found that the GSTR of the said parties showed purchases amounting to a value of rupees 45 crore and odd, while the purchases as per the appellant himself from these 7 parties amounted to rupees 57 crore and odd. Therefore, the AO found the purchases related to these parties to be suspicious and unreliable. Now, my lord, in addition to this,
page 61.
Yes. In addition to this, my lord, comes the answer. During assessment, despite opportunities being provided to the appellant, he was not able to submit any form of confirmation from any of the above stated parties. My lord, it is here, my lord, that the confirmation thing, my lord, gains importance. It is not a singular piece of evidence.
Yes.
No, my lord. During assessment proceedings, despite opportunities being provided to the appellant, he was not able to submit any form of confirmation from any of the above stated parties. He could only produce books and evidences that were based upon his own books of accounts or documents that had been under his control. These circumstances have led to the impugned addition and hence the present appeal. Now, my lord, your lordship will take page 66. Lord, second paragraph at page 66, my lord. From the material on record, I find that the appellant has not been able to discharge his onus at all with regard to the impugned purchases. He has not been able to prove even the identity in the context of the impugned transaction of the claimed sellers of goods. Out of 7 such sellers, in the case of 4, there is no trace of these entities. Even the postal department or the departmental inspector has not been able to trace them or serve notices on them. The appellant, of course, has unequivocally stated that it is not his duty to prove that such persons actually exist at all or not. According to him, he is not bound by law to prove to the assessing authorities that such sellers do have a physical existence and that they are creditworthy to carry out transactions running into several crores. In the case of one of the sellers, where the notice under section 131 was actually served through postal means, there was no compliance at all, either physically or in any other fashion. In the case of 2 persons who had actually been traced, who indeed did physically exist, the results of the inquiry, including through the examination of these persons under oath, have been discussed earlier in the order. Now, my lord, your lordship will take my lord page 75.
Sir, we'll continue tomorrow.
My lord.
Somebody is waiting. Senior is waiting.
Tomorrow, my lord, I may not be able to join in, my lord, since I have an appearance, my lord.
Okay. So actually tomorrow is group 4 and group 6.
Lordship.
Can some junior be there and take notes?
Lordship, kindly permit me to reply on
yes.
Friday,
Because we have to clear the admissions. Only after fresh cases we can take up. In fact, today in the appellate side also, Mr. Jishnu Chaudhary was waiting. He has to make reply submissions. Mr. Datta has completed. That is also running parallelly. How much time you require, Mr. Om Narayan Rai?
Lord, at least half an hour, Lord. I cannot promise, Lord, but I'll try, Lord, at least
45 minutes, probably. And then Mr. Ketan can do that. Parallelly, what you do is you make, both of you can make your written submissions or written notes of arguments. Concise.
We'll do that.
3-4 pages that can be done. So tentatively what we'll do is we'll list it tomorrow. After the understanding is after the group 4, group 6 matters are taken up, or any urgent group 9 they will mention. Because group 9 list today, it will continue tomorrow. Any other mentioning, sir?
Lord, may I seek your lordship's leave to file an appeal without the certified copy? But this is concerning, Lord, operation of a jute mill in Agarpada. Lord,
no, we can grant you leave. 10:30 or 11 o'clock you didn't mention. Now you want. Now you say with short service issue tomorrow. Leave granted. Leave granted. Yes, sir.
I'm seeking your kind leave, Milord, to file a criminal contempt, Milord.
No leave is required. You file it. Why
My lord, the department isn't accepting, my lord. The department is of the view it can only come through the honorable court or through the learned advocate general.
All right. Next, you mentioned tomorrow. Let us see the papers and do it.
There
Yes,
is
sir.
one item 27, my lord, of the hearing list. It is a little urgent because the next year's election process is starting. If your lordship had given precedence, but then
yes,
it
sir.
could not
What
somehow
we'll
be
do
taken.
is tomorrow after this fresh admissions,
Or
we list your matter.
my lord, if it could be made Wednesday, my lord, subject to my lord's pleasure. Wednesday, my lord.
Wednesday will be group 9, yes. Wednesday we will upgrade it.
If your lordship would upgrade it so that can be taken up, because Wednesday it's half day, I think, my lord.
Yes, after 2 p.m. is original side. Now, who will appear for the respondent, sir?
My lord, I'll give a notice, my lord, to the learned advocate who was there, so that the matter I'll give a notice by today, by email, and if necessary, by
that is an election matter, sir?
Yes, my lord. Institute of Chartered Accountants, my lord, election matter. It's hardly, it will take your lordship. I'll take 5 or 10 minutes maximum, not even that all.
All right. On item 27, you please upgrade the matter and
Yes,
list it immediately after fresh admission case.
I'm grateful.
Yes, Lord.
I'm
On
grateful.
Wednesday.
And I'll give notice, my lord.
Yes.
I'm grateful.
My lord, on Tuesday, my lord, will it be your lordship's pleasure, my lord, to have it at a particular time, my lord, 12:30 or something, my lord, subject to your lordship?
Subject to your convenience.
My lord, whatever,
See,
my lord, your lordship.
No, the problem is if you fix at 12:30, if it is not getting over,
Yes.
suppose this matter where
Yes,
senior
yes.
are mentioned, so therefore it will be listed. Please take down. We have heard Mr. Om Narayan Rai along with Mr. Soman Bhattacharjee, Leonard standing counsel for the department. For continuation of arguments, list tomorrow after the fresh admissions in the appellate side matter.
Yes, Lord.
Fresh, yes, appellate side matters. Meantime, parallelly, you start preparing so that you can try to do so. Yes.
My
So
lord,
we'll stop.
yes, my lord. Today, item number 18, lordship is going to take it tomorrow.
Actually, it will run in the list tomorrow, but in all probabilities, it will reach on Wednesday.
Wednesday. Wednesday would be better for me because tomorrow I may not be present. That is why I have asked.
Already, you tell some junior so that we'll say not today. If it in case it reaches, the list collapses. In case it reaches, we'll say not today.
Great. Okay. Great.
Obliged.
Thank you. Thank you.